purpose, I can't see, it's not that I don't want to raise the issue. I can't see in this record that we have how I could do that, how I could meet all the steps involved. So what I'm asking the court to do at this time, have an abundance of caution to protect the record, because years down the line, I'm not going to remember any of what happened over the last couple of days. I do want placed in the record, under seal and preserved for appellate review and for motion for new trial, all of the juror cards, all of the questionnaires for all of the jurors that were summoned in this case, which includes the first group of 200, I don't remember, it's 260 or 289 of the original 600. I want all of those questionnaires preserved and made part of the record, kept under seal for the privacy of the jurors. And I also want all of the juror cards and questionnaires for the second set of 600 jurors, however many appeared, 400, however many appeared. I want all of those records preserved and placed under seal for the privacy of the jurors, but made part of the record so that appellate counsel, in the unlikely event that there was a conviction in this case, that appellate counsel would have a record to determine whether or not, since this isn't a strategic decision, Your Honor, whether or not there was an issue of ineffective assistance of counsel. If the record was there and I simply failed to figure it out, then that would be an issue that might be relevant to appeal. So that's really all I'm asking this morning, is that that information be preserved in the record for appeal and placed under seal. That's issue number, I have it issue number 0 on my list of issues.
Maybe the easier way to do this for efficiency's sake is get through the issues, and then I'll let everybody address what they believe they need to address on behalf of their client.
Very good, Your Honor. Issue number 1 is Juror 219. Juror 219 was examined in court, and it subsequently has turned out that there was an undisclosed social media account, a TikTok account, which contains, I was originally told 3, then I was told 4. Apparently now it is 10 dance video tributes to Ahmaud Arbery that were posted over a period of a month from early May to early June of 2020. The first issue with that juror is with respect to whether they had been candid with the tribunal. Between the general questions and the specific questions, she was certainly obligated to notify us of that account and any connection to Mr. Arbery. And Your Honor has gone to great pains during jury selection over 2 weeks to evaluate the emotional connection that jurors have developed with Mr. Arbery, whether that is a familial connection, a historical connection, or just an emotional connection. People that are watching the video 40 and 50 times, people that have taken upon themselves to go out and play Nancy Drew, for lack of a better description. The fact that these videos were taken, aside from the candid with court issue, there is the issue of whether it's an emotional connection. I have asked the state to consent to the excusal for cause of Juror 219. I don't see any way, I won't say anyway. I'm deeply concerned that this could be a traumatic, if we bring this juror back in, this could be unnecessarily traumatic and challenging, and I just don't want that. And given the notoriety this case receives, you know, certainly if this juror is selected, every media outlet in America will be crisscrossing TikTok trying to find what we're talking about. And I just think that would be unfortunate and unfair to this young lady. So I'm asking, if the state won't consent, I'm asking the state to go ahead and excuse her for cause without bringing the juror in. If the court feels the court needs further examination of the jury, we can certainly do that. Your Honor, I will advise the court that at 10:02 p.m. last night, I emailed the state the links to the 10 TikTok videos, so they have had ample opportunity, if they chose to do that, to review those prior to, well, I don't know when they review it. I'm sure they had to sleep at some point, but I've done the best I can to provide that information to them. Shall I move on? Your Honor, I'm concerned that we need to inquire of the jurors, the entire panel, which we certainly can do. I would just assume have the court do it in the courtroom. If any statement previously made, whether on the juror card, the juror questionnaire, during the general questioning, or during the individual questioning or examination of the potential jurors, after further reflection, whether they believe any of those statements were incomplete or perhaps untruthful, they should raise their hand so they can be individually examined. This addresses two issues that I have raised during jury selection. The first issue being that the parties are relying largely on unsworn statements. And second, the issue that we've already had one juror who's if I recall, whose answer changed, or another who contacted the court after they were examined. In that, given the length of jury selection, that they may have remembered things or other matters that may have changed since they were in here. So I think that general question, if any statement previously made by you, whether by juror card, in filling out the juror questionnaire, or in response to general questions or individual examination, is incomplete or perhaps untruthful in any way, please raise your hand and then individually examine those jurors. That is issue number 3. Issue number 4 is the motion in limine, which was filed this morning at 8:29 or 8:30, Your Honor, and that is a motion in limine which is being raised this morning because it dovetails into the severance issue, which I advised the court we were looking at last night. It is a motion in limine to exclude evidence, argument, and jury instruction as to any purported conspiracy after the fact. Your Honor, there's been a long history with respect to a particular jail call in this case, in which Mr. Roddy Bryan is portrayed, a conversation that he's not a part of, as a quote-unquote ally of Greg McMichael in this case. At first, it wasn't coming in. Now, if I understand correctly, the court has ruled generally that jail calls can come in, although I don't think the court ruled on that specific one. In the state, and give credit for skill as an advocate, the state has been quite coy as to whether they're pursuing that. There is also extensive discussion in a number of witnesses, including a GBI investigator in this case, with respect to what the jurors and the public may view as a mystery as to how the video in this case got out into the public domain. And it is unclear again where the state is going with that. And of course, the state may want to say that it's not part of our case in chief, but we're going to reserve it for rebuttal, and I'm not sure in this case what that really means. But my concern here is that there is no evidence that I'm aware of from the beginning of this case till I stand here today to support any jury charge on conspiracy. It's not there. Now, the state is certainly entitled to a charge on parties to the crime. I understand where that's coming from, but especially given the fact that they have that charge, there's no basis to be charging a jury on conspiracy. And when the state starts presenting evidence of conspiracy after the fact, even if it's to prove the conspiracy before the fact, it's the Jackie Johnson cover-up conspiracy is inexplicably, irretrievably intertwined with this other state after the fact conspiracy theory. If it is, I'll back this video. And what that does for me, Your Honor, is it's difficult to say right now whether there is any antagonism or how serious the antagonism is between defendant Bryan's defenses and the McMichael defendant's defenses. But more to the point, and why I'm bringing this issue up this morning before Your Honor, is we're in a position of antagonistic jury selection here, where jurors that are perfectly capable of serving and certainly could be fair and impartial, Mr. Bryan, have expressed concerns about the length of time between the arrest, between the crime, alleged crime, and the arrest. They've expressed concern about Jackie Johnson and, of course, Mr. McMichael. Obviously, we understand where that's coming from. But if the state is going to be allowed to directly or indirectly present any evidence after the fact, after the shooting of a conspiracy between Mr. McMichael and anybody else, there's just no way the court is going to be able to limit that door once it's opened, and it's going to be getting into matters that are going to put us in a difficult position. And what I'm asking the court to do right now, well, before we start jury selection, is to go ahead and address this conspiracy question, which is, it's technically a jury charge question. A lot of times we don't discuss jury charges until the end of the case. But in this case, this conspiracy matter is extremely important because it goes to the antagonism between defenses. It goes to the antagonistic jury selection between these defendants. And it directly impacts whether we file a motion to sever and whether we are compelled to do it now, or we can wait for the presentation of evidence and see how that evidence develops. I could be wrong, but I think I know where the court's going to be on this, and I think when pressed, the state is going to give up this conspiracy theory because it just creates all kinds of, it's a Pandora's box. But I would like to know where we stand before we start. Mr. Bryan has to make, unless, if I'm right, we could raise the issue mid-trial. The court may not agree with that. And I certainly don't want to put Mr. Bryan in a position where he has unknowingly or unintelligently waived his right to a severance. So that's why I want to address this motion in limine right now. It shouldn't take too long. To me, it's pretty simple. The idea that anything that transpired after the shooting in this case is somehow going to establish a conspiracy either before or after with respect to any issue in this case is fanciful. I think the court could eliminate all of that under 403. The prejudicial impact of that kind of evidence would so far outweigh its probative value that it wouldn't be in any way. But I don't want to be in the middle of the trial and be having this discussion, especially if the court's then going to say that Mr. Bryan has waived his right to raise it. That's issue number 4. Issue number 5 would be a motion to sever. I'm not going to make that motion until we know what the ruling is on 4. And last but not least, Your Honor, we are statutorily, whatever the court rules on Juror 219, whatever that ruling is, defendants are statutorily entitled to 15 minutes to confer before actually exercising their strikes after all the jurors have been qualified. In this case, there are 3 defendants, 7 lawyers, and 65 potential jurors as we speak, maybe 64 in a few minutes. The lawyers have been working extremely hard. I was waiting till midnight to get some clue as to what was going on in the other camp with respect to jury selection this morning. They reached out to me this morning when I was indisposed. We had about 10 minutes to discuss this before we got started. So I'm asking the court, after the court rules on 219 and before we start the examination of the jurors, I'm asking the court, instead of granting 15 minutes, to grant 60 minutes for counsel to confer. Now, beggars can't be choosers. If we can't have 60, I'd take 45. That'd be 15 minutes each. But this is the most complicated jury selection that I've ever been a part of, including several death penalty cases. I think we're entitled to that under the circumstances, understanding the broad discretion the court has in these matters. Thank you, Your Honor.
Anything from the McMichael defendants on those matters?
Your Honor, I would agree that the questionnaires should be filed and left with the court under seal for this record. Other than that, I don't have a comment on the other issues.
Friendsdale.
Thank you, Judge. All right, I'm going to try and take these one at a time. I understand issue number 1 was underrepresentation of white males over the age of 40.
I think what that was Mr. Goff explaining his theory on that, but indicating at this point the request would be to go ahead and seal into the record that juror information.
Correct. And simply for the record, at this time, jurors 1 through 48 we have 19 men and 29 women. We have 36 white jurors and 12 black jurors. 9 of the jurors are white men over the age of 40. That means they're 19% of this panel of 48. So almost 20% of the jurors are white men over the age of 40. We only have 6 black males, and that would be only 12% of the jury panel. And simply also for the record on this issue, as Mr. Goff said, ineffective assistance of counsel coming forward, Limine versus the state, which is 177 Georgia Appeals 763, which is a 1986 case. As the court knows, a defendant is entitled to an array of properly drawn impartial jurors to which he may direct his peremptory challenges. A party is entitled to this matter of right, but conversely, he is entitled to no more. A defendant is not constitutionally entitled to a veneer or jury roll of any particular composition. It just must be picked from the rolls. In addition, Jackson versus the state, 294, Georgia 431, a 2014 case. Any objection to the jury array? In that particular provision, the defendant has the burden of proving purposeful discrimination in the composition of the jury array. That would mean purposeful discrimination by the clerk of court in who the notices were sent to, and that is the burden in that case. At this time, the state, of course, has no objection to making all of the juror cards and questionnaires part of the record. Thank you.
The court intends to go ahead and seal that information into the record then. That should address issue number 1.
That's just all of the jurors.
Yes, those that have, yes.
Thank you.
I understand the request.
And then, Judge, regarding juror 219 with the TikTok account, yes, we have been working 12-hour days and receiving an email at 10 o'clock last night. I was asleep, so I had an opportunity to review it this morning. These are only, I'll call them dance videos, from May and June of 2020. She is a dancer, appears to be professionally trained, and there are many, many of them on her public TikTok account. At this point in time, it appears that she tagged them with hashtag #RunWithMaude. There were some heart emojis, but there was nothing after June of 2020. The state would object to dismissal of her based on not being candid with the court. And this juror was questioned before we ever asked about #RunWithMaude or anything along those lines. So she was in the panel that was questioned well before we combined Black Lives Matter and #RunWithMaude questions. So she was actually never asked about this and never had the opportunity to address it. So I leave it to the discretion of the court as to what the court wishes to do to bring her in here if the court feels she needs to be questioned. But as the court pointed out last night, that's what peremptory strikes are for, to be used when you discover additional information. For instance, Your Honor, this morning, I let the defense know that we had discovered Juror 291, and I have printouts of this, some additional information from her boyfriend's, or now her husband's, Facebook page about when he went ahead and proposed to her. He was wearing a t-shirt that had a Confederate flag on the back of it. And that's something I revealed to the defense this morning so that they're aware of it. I'm not going to motion right now to have her struck for cause, but obviously there's an issue there about something that we have now discovered. So we leave it to the discretion of the court on Juror 219. Regarding...
I'll wait. Or do you want me to address?
Let's get through the responses. We'll just try to keep it in order that way. Okay.
The issue number 3 was asking all of these jurors to raise their hand if a statement previously made after reflection is incomplete or untruthful. I have no idea how many jurors are going to raise their hands, since we may be opening a floodgate to, oh yeah, I forgot to tell you this, and by the way, here's all these reasons why I'm now not qualified, because I really went home and don't want to be on this jury. The relying on unsworn statements in the questionnaire, the defense is the one who initially requested the questionnaire and has had ample opportunity to repeatedly review it with these jurors and get their sworn testimony about the questionnaire. So that is a red herring in the state's opinion. And would they have remembered other things that they want to tell us? Maybe, but we're asking that we not redo individual voir dire of all 65 of these jurors this morning, Your Honor. Regarding the motion in limine that was handed to me this morning at 8:30, as the court is aware, a conspiracy can be a tacit agreement, and the conspiracy charge that the court would give per the request of the state would be that a conspiracy can be found before, during, or after, and it's something for the jury to determine as to the existence of a conspiracy. And they're charged that you can look at what happened beforehand, and we all know that beforehand Mr. Bryan's phone number was not in Mr. McMichael's phone, and Mr. McMichael did not have Mr. Bryan's phone number in their phones. What happened during, the state's argument is going to be, is there was a tacit agreement to go ahead and do what they did on February 23rd, 2020. The fact of the matter, afterwards, what Greg McMichael did to make continued contact with Mr. Bryan, to actually go to Mr. Bryan's place of work, to ask for Mr. Bryan's phone, to take Mr. Bryan's phone from him so he could take it to his attorney, to then download the videos so Mr. McMichael could, I guess, get it published for whatever reason he wanted to do that. The state had not anticipated that necessarily coming in at trial. That was not going to be one of the things that we went over, because that's in Mr. Bryan's first statement to Agent Seacrest. And the only way that it might come up would be on cross-examination of Mr. Bryan, I believe, by the defendants and or the state, depending on his testimony. So at this point in time, we have no intention, I mean, one moment. In our specific case in chief with Mr. Bryan's statements, we don't anticipate it becoming an issue. Now, I can't predict what's going to happen in the defendant's case in chief and what the state may decide to do with rebuttal. So at this point in time, I think this is completely premature to ask the court to make a decision on a jury charge or to lock the state in to promising that this evidence won't come out when I have no idea what the defense is going to be in this case, Your Honor. And the state has no opinion about 60 minutes to confer based on any rulings that you would make, Your Honor. I leave that to the discretion of the court. Thank you.
All right, final word, Mr. Goff.
Your Honor, the state has acknowledged, I believe, that they've had a chance to look at the TikTok videos, and I don't think there's any dispute that they say I won withdrawn or they're hashtagged. As the state acknowledges, on at least one of them, there's actually a heart emoji in the tribute video to Ahmaud. The state argues that these 10 videos were posted at different times over a month period, but a year ago, so that's not relevant. Your Honor, with all due respect, we're excusing jurors for contacts with people that are 5 and 10 and 20 and 30 years old. So posts from last year are still highly relevant. More importantly, Your Honor, in her juror questionnaire, she was asked about her social media. And obviously, she's a frequent TikToker. She's got more videos attributed to Ahmaud Arbery than I have posted in 12 years on all my social media accounts. Clearly, this juror has an emotional connection. We can bring her in and we can talk about it. But clearly, there's an emotional connection to Mr. Arbery. And there's just, we got plenty of jurors here. There's no reason to put this woman through that process. And bearing in mind, until the jury returns its verdict and even afterwards, these jurors are going to be scrutinized, perhaps for years to come. I think we saw that in the Floyd case. And this is just an unnecessary landmine on Juror 219. Unnecessary landmine. we're certainly entitled, both because of the lack of candor and because of the substance of the videos, to voir dire the juror on those two subjects. Moving off of that issue, because I believe after all the discussion, my first request with respect to the record is granted. That's the second issue. My number one, their number two. My number two, their number three, is with respect to asking the entire panel my issue to their number three is we're asking the jury, not the jury, we're asking the court to ask a single question of the jury panel with hands raised for any individual examination that may be required. It may be none. If there are hands raised, then I would suggest that we would all, and I would think the state would also be interested in knowing whether they're relying on information that is no longer correct. Your Honor, and again, the way I have the question phrased is if any answers previously given have changed since submitting your juror cards, juror questionnaires, during your responses to the general questions, and during the individual examination, whether after further reflection you believe that any answer previously given was incomplete, or whether the information provided or omitted might no longer be truthful. And I will certainly defer to co-counsel of the state or the court as the exact wording of the question. My concern here isn't, first of all, to ensure a fair trial, because we certainly want jurors that are selected based on accurate information. And over 2 weeks, it's inevitable that some of the answers have changed, that people will remember things. It may also be that some of the jurors have thought about it and realized that maybe they didn't give truthful answers or complete answers. And I'd rather give them the opportunity to correct that than to be in an ugly situation during the trial or afterwards when things come out. And unfortunately, I have every reason to believe that that kind of thing will happen given the nature of this case. This is not a red herring. This is also an ineffective assistance of counsel issue. And while this issue may be new to the state, I have complained about this issue for years. And apparently, I'm just the crazy guy, okay? But it seems to me that reliance on unsworn testimony, whether by card or questionnaire, is ineffective assistance if it turns out that the information turns out to be incorrect, because the juror is not subject to any real sanction if they're not required to answer and provide the information truthfully. It's an ineffective assistance of counsel issue here, and the only way to cure that issue is for the court to essentially, without necessarily doing it directly or in a way that's obvious to the jurors, is to effectively have their answers be truthful, which is you cover by asking if any answer previously given was untruthful or incomplete. It addresses that issue. It cures any ineffective assistance of counsel claim with respect to the lawyer's use of the juror cards and questionnaires that were unsworn. And there is no other way to do that. And I don't think the state addressed the other reality, is that things change. And just since Monday, October 18th, when we started this process, and what feels like a year ago, a lot has happened in this case, and undoubtedly a lot has happened in these jurors' lives. And for that purpose alone, it is appropriate to ask that follow-up question. I don't think more than 2 or 3 jurors are going to raise their hands, but if it were 20 or 30, it doesn't matter. Our objective here is to have a fair trial. Your Honor, with respect to the motion in limine, I think the state's argument made my point. The state is asking the jury for a jury charge that the jurors can infer the existence of a conspiracy after the fact. The problem is, if we let the jury speculate on whether there's a conspiracy after the fact, now it gets in all the Jackie Johnson cover-up stuff and all these problems with defendant McMichael, which don't impact Roddy Bryant, but it certainly impacts jury selection because the lawyers have to strike juries based on that. And there's no way, although I'm not saying that the state is consciously trying to get into matters that they shouldn't get into, but there's no way you're going to unpack any of this after-the-fact conduct, which they're reserving the right to present. You can't unpack that from the broader issue of that delay or lapse in time and this supposed Jackie Johnson cover-up, which I don't put any stock in, but it doesn't matter what I think. The concern is what the jurors are going to be doing with the charge of the court and the information we provide. I would ask the court to go ahead and rule at this point, subject to a motion to reconsider from the state, that the court's not going to instruct the jury about conspiracy after the fact. If they're going to infer a conspiracy, they've got to infer it from the conduct before or during the shooting, not from things that happened days or weeks later, particularly issues involving elected officials or no longer elected officials. Your Honor, the state cites a correct principle of law as a general rule, but as applied to this case, it's factually unsupported. I think they agree at this point that it will be factually unsupported unless their position changes. But the practical matter as far as antagonism between defenses, and especially antagonism in jury selection, is normally you make a motion to sever before trial, not in the middle of it. And there is some case law that says you can do it during the middle of the trial. But I certainly want to make it clear that we're preserving the right to move to sever if this conspiracy thing comes in. But even then, it still is a problem in jury selection. We can't change the jury after we've picked it. And we have a lot of jurors who were deeply concerned about this supposed cover-up, this conspiracy between Jackie Johnson and George Barnhill and Greg McMichael and who knows how many other people. And inevitably, Roddy Bryan gets drawn into that, even if despite the state's best intentions. So I think that is an issue that needs to be clarified. And I will leave whether we get 60 minutes, 45 minutes, I'll leave that up to the court. But I think the court can understand the complications. And until the court rules on the motion in limine, I don't even have a good feel for how important this issue is during jury selection.
Okay. Again, on that, the first issue, which is the record, again, the court has indicated, I'll go ahead and seal the questionnaires and the cards. As to 219, I had intended to, and I just got sidetracked this morning, to go back into my notes and see what exactly 219 was examined on and where that fell. Based on that review, I'll make a decision on whether 219 gets called back in to discuss this limited issue of what these TikTok videos might be or might indicate. I am not going to ask the panel of 64 the question presented. There was, each party was provided ample opportunity and time to ask questions, and the record is replete with answers from all of the jurors to those questions. I'm not intending to reopen jury selection, which is effectively what that question would ask the court to do. As to the motion in limine, I do believe it's premature. I understand Mr. Goff's concern about it, but it almost feels like hearing the state and Mr. Goff talk about what this conspiracy after the fact is. It's almost like apples and oranges a little bit. I'm not getting a real connection on specifically where we're going with it. Generally, I will look at the evidence at the end of the case to determine whether a charge is appropriate. If that charge is appropriate at the end of the case, we'll go ahead and address that. I do understand and respect the defendant's concern about where Mr. Bryan may fall within that legal theory, but without hearing the evidence or understanding exactly what the state's theory of the case is going to be, at this point, I think it would be premature for the court to make a ruling on that motion. But I do understand that that right is being reserved to go ahead and raise the issue again. I understand where we are, but at this point, I think we're premature.
The only thing I would add, and I'll be brief, is once we started the trial, we're stuck isn't the word for it. We have the jurors we have. That may limit the court's remedial options at that time. I'm just given the complexity of jury selection in this case, I just thought I would point that one thing out. I have nothing else to say.
As trial goes on, we all get painted into corners, so that's where we are. I understand. As to the motion to sever, I understand the defendant's position right now. We're putting that on the record. And as far as time to confer, I'm still trying to work through the panel. There's time now to start talking about it, and I'm trying to figure out where we are numbers-wise. I would like to see counsel and chambers about that so that you all can just get an update on where the court is numbers-wise. Anything then beyond that I'll just start on my left, from the state.
Just an inquiry as to whether the court would reconsider the state's motion to excuse for cause Juror 466. Having pulled Juror 466, my notes from last night, once again, His wife works with Lee McMichael in the exact same department with her. Wife is in medical records. Lee is not her supervisor. However, it would put my wife in a weird situation possibly if the jury came back guilty, put her in an impossible situation at work, probably a better chance that he will not be fair and impartial due to his wife. Wife can supersede objectivity. It would be on my subconscious, and that is why we're actually motioning at this point in time to excuse him for cause. And it is the state's failure for having not motioned at the time. I understand that, but we wanted the court to see if the court would reconsider this.
The court's position generally on any reconsideration is if there is no new information, nothing available to the court that would require reconsideration, then the court will not move on that. So as far as I'm concerned, again, the parties had ample opportunities to examine the potential jurors, and also then had an opportunity to consider the motions that were being made as well as the court's ruling. The court ruled, remains the ruling of the court.
Thank you, Judge.
Anything from Travis McMichael?
No, Your Honor, listening.
From Greg McMichael?
Just one moment, Your Honor. We may have one short motion to make in just a moment, based on something the court just said about reconsidering a juror for whom extrajudicial information has been acquired after the voir dire examination.
I don't think that's not what I just addressed. What I just addressed was information that was known to the parties at the time the court made the ruling.
Right. And that made me infer that if the information was not known to the parties at the time of the examination and has since been acquired, then a motion that was not made when we did not know the information could then be made, as was just done by the state, but based on information we already all knew. We may have one juror, potential juror, about whom we have acquired extrajudicial information not acquired during the examination of that juror. If Mr. Rubin is prepared to go forward on that, you have that?
I do. And Your Honor, I was going to raise that issue. It was suggested to me. I'm just trying to be a team player here, but I'm sure I know which juror this is, and we're going to be joining in that.
If the court will indulge me.
I'm not sure what I'm indulging you in, so go ahead.
Your Honor, we would move to strike for cause juror number 140, based on information we learned after he was voir dired a week or so ago. Juror 140, in response to questioning, admitted to having an arrest out of the Bronx, New York, for a misdemeanor, I think is how he put it. My notes don't reflect he disclosed anything else, and I admit my notes are not as good as Ms. Hoag's. It may not be as good as the state's, but he admitted an arrest for fighting in New York, and he had no opinion on how he was treated, I think was the follow-up question. Our information based on investigation is that, in fact, Juror 140 had multiple arrests and convictions, all for misdemeanors, that we can tell based on New York law, stemming from as far back as the 90s, mid-90s, 2002, 2004, 97, multiple arrests for what looks to be either a stalking or harassment type offenses, and with protective orders as part of the sentence. Some periods of imprisonment, 5 days or a couple months, Again, nothing that rises to the level of felonies, but the lack of candor from the juror, it was concerning to us enough that we followed through with getting the New York records. And given the additional information, given his lack of candor, we would move to strike. And I can show this date. I don't have it printed out, but I can certainly show this date. They may know this already. But we would move to strike juror number 140 for cause based on this new information.
I understand that Mr. Bryan's joining the motion from the state.
Judge, I have no information. This is the first the state is hearing of this morning. I am going to ask my investigator to look into this, but it appears the representation is it's a series of misdemeanors. So there is no felony conviction here, and it appears that this juror was born in 1977, and the dates appear to be around those times. The problem, Your Honor, is, as you know, with any criminal history, often the arrest shows up, the disposition shows up, and something else shows up, and it looks like there's 3 separate incidents on 3 separate dates when it's all one incident. So I would like the opportunity, of course, to look at this. But basically, based on the fact that there is less candor with the court, that's not a reason to go ahead and now strike this juror for cause based on telling us about a misdemeanor he'd had for fighting and then not telling us about a few others, if that's what the case is. And we don't even know if that's the case. So we ask that you deny the motion for cause based on that. Obviously, the defense, just like the state, has the opportunity to use a peremptory strike on juror 140.
Okay.
Your Honor, in my limited experience, which is somewhat dated from the prosecutor's perspective, New York criminal histories can be sketchy, hard to decipher. I thought it was a felony. Coming in this morning, I was told it was a misdemeanor. I would defer to McMichaels and the state on that, but I think that's something we certainly want to concur on. It would be a shame in Georgia, unlike some states, if you have a convicted felon on the jury, that's not harmless error.
And I can add to that too. What we also found was a local news article in the Brunswick News reporting that juror 140 was, I don't think he was arrested, but the article referred to a felony conviction. Of course, we're not relying on a newspaper article to establish that, but it was here in Brunswick not that long ago, and it involved the pulling of a gun on a person at an apartment swimming pool by juror 140, and the police were called out, and the newspaper, of course, as we've well established, media doesn't always get the facts right, reported that he had a felony. That's what set us off to search for this. And again, it doesn't appear that there's a felony on the New York record, but that's how the trail got started.
Okay. All right. Let's get the information to the state. Let the state review the information. We're going to be reconvening here in about 15 minutes. What time is it now? It's 10 past? No, quarter past. So let's go, plan on 10:30. If I could see counsel in the back, just so that we can update everybody on where we are with the panel.
Would that be now or at 10:30? Is that before or after?
That's now.
Okay.
Yeah, thank you.